Let's get started. Good afternoon, and thank you for joining us for the kickoff to the IP Lunch Club. My name is Mackenzie, and I'm one of the 6 team members of the Sandbox Center. For those who may not be acquainted with SBX, we're located online and downtown Barrie, and we connect people and their ideas to business resources so that they can create a better life through business. We're thrilled to be once again continuing our partnership with IP Osgood's IP Innovation Clinic. Protecting the ideas and creation of artists, inventors, and business owners allows businesses to grow and encourages innovation. For those who may not be acquainted with IP Osgood or may not have attended a previous session in our space before, we're happy to have you with us today. IP Osgood is an innovation and market legal clinic staffed by law students and operated in collaboration with York University's Innovation York, Norton Rose Fulbright LLP, and the International Law Research Program at the Center for International Governance Innovation. It serves a clientele that is needs-based and underserviced, such as individuals or startup companies who do not have the resources to hire a lawyer, patent agent, or other advisors. Under the guidance and mentorship of the supervising lawyers, Innovation Clinic Fellows provide one-to-one legal information services to inventors, entrepreneurs, and startup companies to assist with the innovation and commercialization processes. The partnership we hold is so incredibly unique to be able to provide the opportunity for students to have hands-on experience supporting businesses, and then similarly for businesses to have access to this expertise is such a win-win. So we're so appreciative of it. But before I continue with introducing the IP Osgood team for today's session, we're really grateful to have Barristan Law join us for this series as a presenting sponsor. The team at Barristan are not only an active and committed contributor to SBX regularly, but continue to serve the local region when it comes to protecting business owners and improving innovation. So I'd like to just introduce Alexandra Paul and Chris Holmes of Barristan Law to quickly share a few words. Thanks for joining us today, guys.
Thanks, Mackenzie. My name's Chris Holmes. I'm an associate lawyer at Barristan. I practice in corporate law, wills and estates, and real estate law, and I'm currently working under our registered trademark agent, Graham Knight, to become a registered trademark agent. So working towards that designation right now. We're really happy to be partnered with Sandbox and IP Osgood with this. And these are definitely important points, for small business owners, protecting your IP and making sure, you're proactive in this. IP Osgood sounds like a great resource because most people can't afford a lawyer at the outset. And that's really when you need it most. Because most of the times we get involved with this, it's been 2 years, 5 years, 10 years. They've never taken the proper steps to protect their intellectual property. And now it's going to cost them a lot more to defend that and try to establish those rights. And, you're not always successful. So if you make sure you get your ducks in a row properly at the outset, that's the best time to do it. And, if IP Osgood can assist you doing that at a lower cost or free compared to our legal fees, I think that's a great resource for people that can't afford it. I'll pass it over to Alex.
Hi, I'm Alexandra Paul. I'm an articling student at Barristan. We're a mid-sized full-service firm. We have offices in Barrie, Bracebridge, Huntsville, and Collingwood. We have around 30 lawyers practicing in the area of business law, intellectual property, family, municipal, real estate, wills and estates, civil litigation, employment law, the list really goes on. And we're just really excited to be sponsors for these IP lunch events. And we are so thrilled with our partnership with the Sandbox.
Awesome. Thank you so much for the remarks, Chris and Alex. And thank you again to Barristan Law for sponsoring this series. Today, in part 1 of the IP Lunch Club, the IP Osgood team will be guiding us through some key highlights of patent and trademark strategies, which startups and entrepreneurs should consider before and while they form a company. If you have any questions at all throughout the session, please don't be shy. Feel free to use the Q&A feature or chat, and we'll make sure to address them just at the end of the session. So without further ado, let's get started. I'll pass it over to Emma of the IP Osgood team. Thanks, Emma.
Hi there. Good afternoon, everyone. Welcome and thank you for joining us in the IP Lunch Club. My name is Emma Abbas, and I'm an aspiring IP lawyer and a student at law at the IP Osgood University and the IP Innovation Clinic. I'm coordinating the wonderful IP Innovation Clinic students on behalf of the IP Osgood and the clinic, who have worked hard to bring these presentations to you. The clinic aims to support creators and startups and entrepreneurs, as mentioned by Chris and Mackenzie earlier, as opposed to the higher fee that the lawyers charge. The clinic charges only a $50 fee to everybody or anybody who's coming in. That is the only fee that we charge. There are no other expenses. The clinic aims to support creators and startups and entrepreneurs to create awareness and to launch their IP commercialization process. So without further ado, I'm really excited to introduce you to Kier, Maddie, and Yain, who will be bringing these presentations to you today. Thank you.
Thanks for the introduction, Emma. My name is Maddie, and I'll be presenting today with my colleagues Yain and Kier. And we'll be going over intellectual property law considerations for startups and entrepreneurs. So there's we'll be covering the top 3 things that startups and entrepreneurs should be considering both prior to and during the course of business. So this includes things like ownership, public disclosure, as well as selective protection. I'll kick things off first by talking about what is an inventor. So the Patent Act doesn't actually define what an inventor is. So for this, we actually have to look to the case law. And according to the case law, an inventor is the person who conceives of the idea. So this is kind of the idea man, whoever puts it into words and into practice. And then from there, they take that conception and turn it into what's called a practical or workable device. So they make the idea a reality. What's not considered an inventor, however, is the person who just came up with the problem. So they're like, hey, we need a solution to this, but they don't have the solution. Similarly, people who just paid for the invention are not considered inventors. Similarly, if they were to just provide some lab space to come up with some new wonder drug, they also wouldn't be considered an inventor. And on that note, people who verified the final invention would also not be considered an inventor. They just kind of came in at the end and made sure everything worked according to what the inventor thought it was going to be. So what we need to consider separately from this is who owns an invention. It's important to distinguish an inventor from an owner because they're not always the same person. So if you've created an invention on your own time, then this likely isn't an issue. However, when an invention is created in the course of employment, then sometimes things can be a little bit hazy. Typically, in the eyes of the law, the inventive employee is favored. So this means that if you made the invention at work, typically you can own it. However, where the employee has agreed to a contract that kind of states the contrary, or in the case that the employee was actually hired for the purpose to create the invention, then often the employer is favored as the owner of the invention. So shown on this slide here, there's essentially those 2 kind of exceptions to when the employee is favored as the inventor, namely if you kind of signed that away at the beginning, or the whole reason for you having the job was that you were coming in to invent something. Now, in the case that you were in the second grouping and that you're an employee hired to invent, the courts have laid out 8 factors that you need to consider in the employee and employer relationship. So essentially, this is looking at why you got hired in the first place, be it for your past inventive skill, kind of known for an inventor, and that you were required to kind of make an invention in the course of your work. And then overall, the nature of the work and the behavior of both the employee and the employer are very important things to look at. So shown here are these factors that none of the 8 are necessarily a be-all of end-all of answers, but they're things that are important to consider when determining who owns an invention. The first being kind of the most obvious that we've talked about is, was the employee hired for the purpose of inventing? Second to consider is that had they made inventions prior to this, were they known to be an inventor and maybe hired for that reason? Within the workplace, are there incentives that encourage product development? Is that kind of par for the course? And another big one is the employee conduct. So once the invention was created, did the employee, even if they're the inventor, suggest that the employer was an owner? So how did they behave? How did they treat the invention? And in their contact with their employer? Next is to look at if the invention was a product of the problem the employee was solved. So was there a duty to create this invention? Were they hired to solve a problem and the invention was the result of it? Additionally, to look at if the invention flowed from consultation through the standard company channels, which essentially means did they ask for help through colleagues, through kind of the people above them, their superiors? Was this a collaborative effort? throughout the company. It's also important to consider if they're dealing with highly confidential information. So was there kind of trade secrets involved, stuff that they only could have gained through the course of the work? And lastly, was it a condition of the employment that the employee could not use company ideas to their own advantage? So something that the company kind of already had a notion of this, and then the employee kind of ran with it to create the invention. So were they using this knowledge they gained to benefit their own product? Now, it doesn't always have to be so black and white as an employee or an employer of an owner, or of an invention, excuse me. Joint ownership can offer a compromise in which more than one party can own the invention. So this is something to be aware of, particularly for entrepreneurs that come out of academia. In those cases, you'll likely need to disclose to the employer and figure out how to proceed from there. So as an example, I did my PhD at the University of Toronto, which is why I showed the University of Toronto here. So in this case, not only are there supervisors and collaborators to consider, but the institution itself plays a role. So in cases like this, you might be a joint owner, or you could still potentially be a sole owner, but maybe you have to share in the downstream revenue. So that's kind of what is shown here. So if you invent something at the University of Toronto and you own it, the University of Toronto still gets 25% of the revenue. Alternatively, the university may end up owning it, in which case you get entitled to 40% of the revenue. So there's various ownership and agreements that you can come to with an institution that are important to consider in the early stages of an invention. So now, in the case that there is more than one owner of an invention, and you decide to make a company out of this, you now have more than one co-founder of the company. So when you're starting a business now based off of this invention, it's important to have all your ducks in a row to avoid problems down the road. So essentially, all the parties need to be on the same page when it comes to the terms of the relationship. You can think of this as a co-founder prenup. So everyone kind of starts off with the best of intentions, but it's good to have a safety net in place should things go south. So some things to consider in this founder agreement is who gets what percentage of the company should you decide to split up. What are the roles and responsibilities of each of the founders to make sure you have this laid out ahead of time so no one gets hurt feelings or disappointed. And then also, what happens if a founder decides to leave, you go your separate ways? You need to have a contingency plan in place. Do the founders buy back shares that were originally given to the co-founders? You don't want to have a case where the co-founder can just leave and take part of the invention and the company with them. Which brings me to that final point. It's really important to be sure that the intellectual property is assigned to the company and not the individual inventors, which is kind of exactly that situation that I just talked about. It's really, a lot of the times the inventors may have invented this before starting the company, so in which case they can assign the IP to the company, and this can be done in exchange for shares of the company. And then similarly, any subsequent IP that comes out of it should be in the name of the company as opposed to the co-founders, because at the end of the day, people are human. So it's good to have this all under the umbrella of the company or the corporation. Now, beyond your personal IP as the founder, and once you've worked out the IP for starting the company, it continues to be important to protect all of your future IP. So IP that is created during the business should be assigned to the company, and you're ensuring that the IP created by employees is also assigned to the company. So you'll need an agreement to state that. Similarly, IP from previous jobs or ventures may want to be held separately if it's got nothing to do with the company and it's kind of something in your own name. It's not even just your standard IP, patent, copyright, trademarks, but things like trade secrets or confidential information that you might have from a previous job. You need to be aware of those agreements that are in existence. So for instance, if you once upon a time worked for Coke and you knew how Coke was made, that's a trade secret recipe. So then if you hop ship and you go work for Pepsi, you couldn't share that information. So you need to be aware of the IP and the agreements from previous engagements for all of your employees. And that leads into the confidentiality agreements, because they're very important. Exactly for the Coke Pepsi kind of reason, you want to avoid any unwanted disclosure, so that an employee using the information that's gained from work could then influence an invention outside of work. So you want to make sure you protect those secrets within the business. And then the final thing to consider is that independent contractors are presumed to own their own IP. So if you hire a contractor or a consultant and you want them to work with confidential information to build up your IP, you need to have an agreement to the contrary to ensure that you're protecting those intellectual property assets. So I'll hand it off to Yaen now.
Okay, thank you, Maddie. I will continue to talk about the public disclosure and patent application related issues. So after working out who's the owner of the invention, the owner of the invention can apply for a patent or assign someone to do so on their behalf. But what is a patent? There will be another launch talk in the following weeks focusing specifically on patent. So I'll just quickly go through some basic information here. And patent is a statutory monopoly made pursuant to a Patent Act, and patent grant their owner rights to exclude others from doing claimed acts for a limited time. So for the patenting process, someone developed an invention, and they're the inventors, as Maddie previously mentioned. Patent agent or the inventor can file a patent application with the Patent Office, the Canadian Intellectual Property Office. And these patent applications are reviewed by an examiner, and there will be correspondence between the patent examiner and the patent agent or the inventor, depending on who's the applicant here. And this process is called patent prosecution. So if the examiner is satisfied that the patent should be issued, the commissioner of patents issues the patent. But before you jump in to file patent application, you might want to seek assistance from patent agent, or you might want to come to our clinic so we can do some prior art search for you. And you might also need to prepare for other documents for yourself. Next slide, please. So from your idea to an operational business, you come up with this idea, you might do research, there might be like prototypes, and you might talk to potential investors, or you try to put the product on the market. And up until your business starts generating profits, we can see that you will definitely discuss with other people. And it's also very possible that you might publish this on a journal or attend a conference if you're from academia. And next slide, please. But why is this type of like public disclosure will be relevant to your patent application? Because in the Patent Act, the definition of what an invention is, the invention means any new and useful art, process, machine, manufacture, or composition of matter, or any new and useful improvement in any art, process, machine, manufacture, or composition of matter. So the key requirements of patentability here are these three requirements. One is new and is not obviously disclosed, which also means it's like first in the world type of thing. And second is being useful. It can be used in the sense that it was intended. That means it's functional and operative. And third one is inventive, non-obviousness, which means it's not mere workshop improvement. So it's not obvious to someone of average skill who work in the field of your invention. Next slide, please. So as we mentioned in the previous slide, novelty means the invention has to be new and not obviously disclosed. But what if you have the inventor has disclosed the invention? Like we previously mentioned that you might attend a conference or there be other situations like that. So this situation might jeopardize the patent rights in some jurisdictions. However, in Canada, there's a 12 months grace period, which means in order for the inventor to obtain the patent in Canada, the applicant has to be the first person to file the patent application. And the patent application has to be filed within 12 months of the first public disclosure. Next slide, please. And so in addition to the public disclosure, what else should you pay attention to? There's a very important thing is the proper documentation. As Madipris mentioned, there's all these essential legal documents, and there might also be like company ownership agreements or written agreements for IP assignments, employment contracts, as mentioned earlier, or those non-disclosure agreements. it's very important to keep your documents organized and safe, and those documents better be dated. And like maybe you're wondering, when will these documents like become important? It might be important for your business operation, for tax filing purposes, or you're seeking for finance, or like there might be potential lawsuits, or if someone wants to buy your company or you want to sell the company, the buyer might have their lawyers conduct due diligence on your company, and they would like to see those documents as well. And next slide, please. Thank you. So we talked about public disclosure in patent and the importance of proper documentation, but how about those other intellectual properties that's non-confidential, like logos and business names? They're non-confidential, and obviously you want people to know that your products or your service is out there, and the registration of your corporate name or incorporate your business does not equals to like trademark application. So you might consider to register your primary brand or mark for your product and services. But how to do it in a cost-effective way, like as previously everyone mentioned, that being an entrepreneur, and there are also many concerns about the finance. So I'll hand over to Kier to talk about how to do it in a cost-effective way. Thank you.
Thank you very much. So you have your intellectual property. Now what? Next slide, please. Let's say you're an enterprising young entrepreneur who has started their new brand. I know that must be a real stretch. Now, knowing a thing or two about trademark law, or at least I hope you do a little bit at this point in the presentation, you probably know that a trademark is a good way to protect your brand, and a registered mark provides a far broader protection than an unregistered mark. So you should probably apply for one of those, right? Next slide, please. Well, like most things, the answer is it depends. As much as a future intellectual property lawyer like myself might be tempted to seek every conceivable protection available to us, the reality of the situation isn't quite that simple. For example, going back to our earlier example, your brand is going to be the next Amazon or Indigo or whatever. The point is you're going to do everything, so you should protect everything, right? Next slide. Well, no. Applications to register trademarks require the applicant to register for the class of goods or services. These cover everything from guns to cars to imitation leather. And for each class, there's a fee for that registration. Next slide, please. The fee for the first class of goods or services in the year 2021, according to the SIPO website, is $336.60, and an additional $102 for each subsequent class. So doing a little math, and I didn't come to law school to do math, so bear with me, please. If one was to apply for a trademark for each of the 34 classes of goods, 10 classes of services, and the class for goods and services that don't fall into any other class, it would cost $4,926.60. And that's not even mentioning the fact that you'd have to actually operate under each of those goods and services, or risk expungement, the renewal fee, paying a trademark agent. Next slide, please. Now, this probably seems a bit excessive because, yeah, that's the point. You, the shrewd entrepreneur, wouldn't register a mark under every class of trademark because you don't need protection under every class. You'd apply for those your brand actually operates under or intends to operate under in the immediate future. These fees might not seem like a lot, but to a startup or entrepreneur with limited funding, they could be make or break. That's the message I'm trying to get across. It's vital to understand not only what could allow for protection under intellectual property law, but what you need to protect under to conduct your business and how to balance the cost of that protection. Next slide, please. And this doesn't just apply to trademarks. While it's sometimes wise to apply to register copyright in a work, you certainly wouldn't apply for registration for each potentially copyrightable work your business churns out. Otherwise, you'd be registering every email and PowerPoint presentation, and that, again, exaggerating, but you get the idea. Next slide, please. In the real world, I think I went too far ahead. One back, please. In the real world, patents are a more relevant example. As, like with trademarks, they can get expensive. Application fees, maintenance fees, search fees. Patent office really likes its fees. Patent applications are a lengthy, expensive process, and for cases such as those involving patents, even remotely computer-related, that may require extensive back and forth with the patent office, numerous revisions, and after all that, you might even come out with the process with a patent. Next slide, please. So, am I suggesting not to bother with IP protection? No. Excluding the fact that if everyone decided to suddenly not use intellectual property law anymore, it would destroy my career, IP protections are important if you don't want to risk your brand or invention being pulled out from under you. So, what should you do? Next slide, please. Well, again, it depends. Not all startups are the same, and the protections they require vary as much as they do. What I can offer is to give you some helpful questions to consider. Do you require IP protection? And if so, what kind? What protection can you not only afford, but maintain? Does your brand require the broad protections of a registered trademark, or will those of an unregistered trademark suffice? What classes of goods and services does your brand deal with or will deal with in the immediate future? Do you have an invention that might qualify for patent protection? Does the nature of your business require that invention to be patented? And do you want the added security of registering your copyright? Again, these questions aren't intended to be all-encompassing, just to help you consider what sorts of IP protections that your startup might pursue. But again, the whole point is what you should pursue, or what, rather than anything that could possibly be pursued.
Awesome. Thanks, team. Well, we do have a question here. If anybody else has any other questions, feel free to chime in. We do have the experts here and we have their time. So I'll get us started with one question. And that is asking, does composition of matter mean the creation of content to be used in a workshop or creation of written material? Or does that fall under the copyright?
I think I will give that a go. I think that was related to the definition of invention, I guess. So for the example that you take about creation of written materials, is more likely to be falls under the copyright region. And for the composition of matter here, and the definition is more like, for example, those chemical compounds or those things that's more likely to be the definition of that, chemical or mechanical mixture, those types of things. I'm not sure if that answers your question.
Somebody's asking, many entrepreneurs tell me they won't bother applying for a patent because even if they achieve a patent, the millions of dollars to defend it are beyond their reach if a large company violates their IP. So maybe perhaps do one of you have an opinion on that, or how to kind of settle that debate or ease entrepreneurs their mindset when it comes to actually going forward with applying for a patent?
I can weigh in a little bit on that. I would say that's probably not an uncommon fear. Patents are notoriously expensive, and then there's maintenance, and you're right, to defend them should someone infringe, it can be expensive once you add in lawyer fees and the long drawn out court process sometimes. But I think that's not the only purpose of a patent. The patent also, in theory, gives you the 20-year monopoly. So that's kind of what it's designed for. So even regardless of any infringement, and let's hope nobody infringes it, that'd be great. It kind of sets your fences. So this is your invention, and by patenting it, you're actually preventing some other big corporation from coming in down the road and making that invention. So it puts you on the market without kind of giving somebody else a free pass to do it. Technically, if you weren't to get a patent, all you could, and you had maybe published it somewhere, it would maybe count as prior art against someone. But it gives you the power to own it. And then you cross your fingers and hope you don't infringe. And if that's the case, then you cross that bridge when you come to it. And if it's really as lucrative as it is, hopefully you can afford some lawyer fees to do that. But it's well worth the investment if you really do have a good product. And
typically, how long is that process?
The process of filing?
Yeah.
So the answer, I guess the typical lawyer answer is it depends. But by the time you have a lawyer and you draft the patent and things like that, it can happen very quick if you've already disclosed, because there is the 1-year grace period. So if you're kind of pushing the clock on that, there's going to be a scramble to get it in before you lose that window. In an ideal world, when you haven't disclosed yet, I'm not saying it'll take a year, but they'll take a bit more time to really finesse it. But once it's filed, a lot of the times it'll be like an 18-month window, and you get kind of a response back from the patent examiner, to which you might have to respond to, likely, if I say might, likely have to respond to whatever changes need to be made to the claims or challenges brought up. So it can be a back and forth process kind of over a couple of years, kind of start to finish, which can be a little daunting, but it's a lot of time and money and effort that have to kind of go into it.
Awesome, thank you. And David had said, helpful answer, Maddie, thank you. So he's thanking you as well. Annette is asking, how do we reach out to the clinic to assist with trademarking, and do you assist with copyright as well?
I can field that since everyone else already fielded one. To reach out to the clinic to get assistance, you can go to the website, which I'm sure we have linked somewhere, the IP Osgood Innovation Clinic website. And from there, you can find a link to becoming a client, and you just have to fill out a questionnaire, and that information will be relayed to us, the clinic fellows, and then we'll help you with that process. With regard to copywriting, copyright is interesting because if you create a work under copyright, you already have a copyright protection there. Like, it just exists. Like, you don't have to actually file for anything. You can file for a registered copyright. It's not super common, but it's basically just like you putting down a flag and being like, I made this, and it is helpful if anyone ever did try to steal your copyright, but you don't have to do anything for your copyright to vest in a work. So we can help you like that, but so you're already good on copyright is what I'm getting at.
Awesome. Thank you. And I see Yain actually put in the link to IP Osgood's becoming a client page there as well. And we'd be happy to make any connections if you wanted to just reach out to the Sandbox as well after the session directly. Perfect. And Kathy is asking if this PowerPoint information is on your website or can be referred to. We can definitely connect you to that, Kathy. We are recording the session, so we are going to be providing that as a resource to all of the participants today who either registered and couldn't make it or want to refer back. So absolutely.
I would also just chime in real quick there. In addition to that, if you wanted to go to our website, we have a chat bot. So if you have any other questions to follow up, and there's anything you don't understand or want more information on, you could kind of type that into our chat bot, and that could help you in the interim while you're waiting to get in contact with the clinic or waiting eagerly for the next installment in this series.
Absolutely. Thanks, Maddie. And yes, funny enough, our actual last session is going to be all about that chatbot. And I'm so excited to learn more about that newly launched chatbot. So that will be a great session. If anybody doesn't have any other questions, we'll probably wrap this up now, but like we said, this session is recorded, so we'll be providing this as a resource as well. Thank you for all the information you provided us today, guys, and thank you for joining us. I hope you were able to take away some insights that can be applied to your business or to get the wheels turning at least. We encourage you to join us next week, same time, for part 2 of the IP Lunch Club, where we'll be exploring the strategies in which entrepreneurs and small business owners can profit from their innovative ideas and commercialize their intellectual property. And Meg will be putting that in the chat there as well, so you can go register right away by clicking the link. Thank you again to Barristan Law for attending and sponsoring today's session. We're super appreciative. And that's it for us today. We hope you have a wonderful rest of your day and hope to see you next week. So thanks, everybody.